The president did not want the hidden information made public. The presidency, however, is not a private kingdom. This truth was affirmed by the Supreme Court of the United States, ruling 8-0 on this day in 1974. President Richard Nixon had to hand over tape recordings of his conversations in the Oval Office. The decision in United States v. Nixon marked the end of Nixon's presidency. 16 days later, he resigned. The 37th president had attempted to withhold the tapes, arguing the office of the presidency required absolute confidentiality to function. The justices, appointed by presidents of both parties, including Nixon himself, rejected the idea. They held that the president is not above the law. The tapes, once released in full, contained what the prosecutor suspected: evidence of Nixon's efforts to obstruct the FBI's investigation into the Watergate break-in. The so-called smoking gun tape showed Nixon not only knew about the cover-up, he directed it.
Hey friends, John here. So this is happening right now. Nixon resigned on August 9, 1974. Not because he was impeached, but because the political foundation of his support collapsed. Defenders ran out of arguments, legal protection failed, and the gap between his public claims and the official record became unsustainable. The lesson is that political survival depends on more than just holding office. That sequence matters enormously right now because history has a way of repeating itself in patterns that are recognizable to those who pay attention. The resignation was not a sudden decision. It was the endpoint of an accumulation. Legal findings, political coalition fracturing, bipartisan convergence on accountability, and the specific moment when the people who had been defending the president ran out of defensible positions and told him the votes were not there.
Once the truth was unavoidable, Republican support collapsed. More than the burglary, the conspiracy to hide it undid the president. The lies to the public, the pressure on investigators, the abuse of power to evade accountability. It's not the crime, it's the cover-up, became a political axiom. Secrets about presidential acts against the Constitution cannot be hidden merely for political convenience. The most powerful man in the country must submit to scrutiny when the law demands it. These are the standards the judges affirmed. Concepts as old as the presidency itself, designed to guard against the founders' greatest fear, a leader who confuses personal interest with the national good and believes no one has the right to question him. On this day in July 1974, the system, designed when recording devices were made of parchment, ink, and quill pen, told the president no.
And the reason the resignation inevitability framing keeps appearing around Trump is not that commentators believe he is temperamentally capable of resigning. He has spent his entire public career demonstrating the opposite, that he digs in, attacks, and refuses to acknowledge defeat under any circumstances. The reason the framing keeps appearing in the analytical writing of people who study these things seriously is that those analysts are tracking whether the convergence that made Nixon's position untenable is building around Trump in ways that are historically recognizable, whether the legal machinery, the institutional pressure, the accumulated court rulings, and the progressive erosion of the political protection that has been keeping the most consequential legal consequences at bay are reaching the specific combination that historically precedes a presidency.
A U.S. appeals court has ruled that most of President Trump's tariffs are illegal. The judges said while the president had considerable powers to respond to national emergencies, these didn't explicitly include the power to impose tariffs or taxes. President Trump used a power under the International Emergency Economic Powers Act when he implemented his reciprocal tariffs, which have been a cornerstone of his foreign policy. The court said the duties can remain in place until the middle of October to allow for the case to be heard by the Supreme Court. The decision doesn't affect tariffs issued under other legal authorities, such as those on steel or aluminium. Mr. Trump has called the ruling incorrect. He posted on his Truth Social platform earlier saying all tariffs are still in effect, calling the court highly partisan, and said that incorrectly said the tariffs should be removed. But he said they know the United States of America will win in the end. Mr. Trump went on to say if these tariffs ever went away, it would be a total disaster for the country. Now, he says, with the help of the Supreme Court,
becoming operationally and politically impossible to continue. And right now, something genuinely significant is happening that demands our attention. The Supreme Court has been building a legal landscape that is more hostile to the specific claims of unlimited executive authority and personal immunity from accountability than any single dramatic ruling could be. The nightmare for Trump is not any one ruling. It is the specific architecture of what the court's accumulated rulings have built together across multiple terms and multiple cases. The immunity ruling that confirmed zero immunity for unofficial conduct and explicitly set up the application process.
We will use them to the benefit of our nation and make America rich, strong, and powerful again. Our North America correspondent, Anthony Zerka, has been following the developments. I spoke to him a little earlier. Mr. Trump says he has the right, the power, the responsibility under national emergencies to use tariffs to protect America. What did the court have to say about that?
Well, the court disagreed. And honestly, it's the second court now to disagree. The lower court, beneath the appellate court, also held that this was an impermissible overreach on the part of the president, that he was reading too much into this emergency law that dates back to the 1970s, and that it didn't give the president authorization to basically impose tariffs on whatever country he wants, whenever he wants, and whatever extent he wants. They said that the Supreme Court precedent that they were looking at suggests that for a president to have this kind of broad power really has to be grounded in a law, and Congress has to explicitly say that the president has this sort of authority, not just the president interpreting it in what they said was a very strained manner.
The tariff ruling that found he broke federal law with his emergency powers and established the major questions doctrine as the binding standard for every future emergency authority claim. The ongoing term, decisions blocking National Guard deployments, constraining emergency orders, and progressively narrowing the administrative space within which unilateral executive action can operate without judicial invalidation. And the birthright citizenship case still pending, where the oral argument questioning from multiple justices, including conservatives, signals that another major invalidation of claimed executive authority may be weeks away.
These national emergencies that Mr. Trump said gave him the authority to do that, what was he referring to?
Well, that was the text of the law gives the president in national emergencies authority to impose economic sanctions on other countries. Past presidents have used it to do that. For instance, on Iran after the hostage crisis, Jimmy Carter used it to impose sanctions on that nation. Other countries have used it to impose various sorts of restrictions and penalties. But no president has read a law as broadly as Donald Trump has. But he's saying that the emergency power that is contained within this law gives him this kind of authority.
The Supreme Court then for this, Anthony, next?
It looks like it. Obviously, the court could decide not to take up this case, but I don't think there's anyone who believes that they won't look at this. You have to remember the court is going to move as fast or as slow as it wants, but it goes back into formal session at the beginning of October. And this is certainly going to be one of the first cases on this list to look at on whether to agree to hear it.
Together, those rulings and pending decisions constitute a legal landscape that is more threatening to the sustainability of the Trump presidency than anything we have seen before. The nightmare is the architecture, and the court has been building it one decision at a time. The July immunity ruling created the three-tier immunity structure that has been progressively applied by lower courts to find Trump's most legally dangerous conduct falls in the unofficial act zone rather than the protected zone. But the nightmare dimension of the immunity ruling is not just what it found. It is what it left unresolved and what the process of resolving it looks like from the inside of a presidency. Every immunity fight that a lower court is conducting, every application of the framework to a specific category of conduct, is a legal proceeding that generates public filings, oral arguments, judicial opinions, and documented findings about what the president did and what it was legally equivalent to. The immunity fights are not happening in sealed proceedings or classified settings that the public cannot access. They are happening in public federal courts, generating published opinions that are accessible to every journalist, every legal analyst, and every member of Congress who wants to understand what the courts have formally determined about this specific conduct. And the specific findings those opinions are producing, this category of conduct is unofficial. This pressure campaign falls outside the scope of legitimate presidential authority. This coordination activity is the work of a candidate trying to retain office rather than a president exercising governmental functions, are building an authoritative public permanently documented and specifically attributed judicial record of what American courts have officially and formally determined about Trump's conduct. That record is the nightmare in the operational sense. It is being assembled in public, one immunity ruling at a time, in proceedings that are generating formal written judicial opinions rather than anonymous sources or disputed political claims. And it constitutes a documented judicial account of the president's conduct with specific legal conclusions, specific factual findings, and specific citations to evidence that no political defense can simply dismiss as partisan accusation in the way that a congressional speech or an investigative report can be dismissed. Published judicial opinions from Article III courts applying established legal frameworks are not partisan attacks. They are the law's official account of what happened, and that account is becoming progressively more damaging with each new ruling. Now let us talk about the tariff ruling and why it functions as a critical component of the nightmare landscape. The court found that Trump broke federal law with his global tariffs. That finding is not just a legal determination. It is a publicly documented Supreme Court level official statement that the President of the United States acted in violation of federal law in a policy area where he had publicly and repeatedly claimed the authority to act unilaterally. The political dimension of that specific finding is significant in ways that extend substantially beyond the legal dimension and into the domain of presidential credibility and governing narrative. A president whose signature economic policy, the tariffs that were described as the central pillar of his America First economic agenda, has been found unlawful by the Supreme Court, including by two justices he personally nominated and publicly celebrated as his appointees. Is a president whose claim to be acting within constitutional limits has been officially and publicly challenged in the most authoritative legal form available. And the specific economic consequences of the tariff ruling, the potential for refunds of tens of billions of dollars, the disruption to the trade policy that was supposed to be one of his signature second-term accomplishments, the signal to foreign governments and trading partners that his tariff authority is legally constrained in ways his administration had denied, are consequences that compound the legal defeat with practical governance failures that affect his ability to accomplish the policy agenda that was the political justification for the presidency. And then there is the civil fraud enforcement track, which functions as the third and most viscerally concrete leg of the nightmare ruling stool. The component that is closest to the overnight collapse dynamic because it is moving through enforcement phase legal proceedings that are specifically designed to be resistant to delay and that do not pause for political considerations or wait for the normal legislative calendar. The New York civil fraud judgment is final. The appeals have been exhausted. The enforcement machinery is operational. And the specific enforcement tool of the court-appointed receiver, which would place operational control of Trump's most iconic business assets under the authority of an official who answers to the court rather than to Trump, is the most visceral and most publicly visible embodiment of a presidency under effective legal siege. Because a president whose personal business empire is subject to court order management and potential for sale is not just legally exposed in the abstract. He is publicly, visibly, tangibly exposed in ways that affect the physical landscape of the brand that has been the foundation of his political identity. The buildings with his name on them potentially being operated by a receiver appointed by the judge who found he committed systematic, deliberate fraud. The Trump brand, the physical, tangible, publicly visible embodiment of the political identity that made everything else possible, potentially under court management in the most public real estate market in the world. That is the nightmare, not a metaphor. A literally occurring enforcement action that is happening in the most public possible way, in the most iconic real estate in the country under court oversight, that has already survived every appeal and every emergency stay motion his legal team has filed. And here's what ties all three components of the nightmare landscape together. The immunity fight record building that is documenting specific conduct as unprotected. The tariff ruling unlawfulness finding that is documenting specific executive action as breaking federal law. And the civil fraud enforcement that is translating legal findings into operational physical world consequences. Together, they converge into the single overarching question that serious analysts are now asking about resignation. The question is not whether Trump has decided to resign. He demonstrably has not and demonstrably will not, absent a specific and extraordinary set of circumstances. The question is whether the combination of these three components is building the specific kind of cumulative political and institutional pressure that historically produces the circumstances under which even a president who says he will never resign eventually faces a moment when the cost-benefit calculation changes. And the specific thing that will change that calculation, that has always changed that calculation historically, is not the legal findings themselves, but the political response to them. Whether enough of the Republican Senate coalition is reaching the point where defending the specific conduct documented in the immunity fight opinions is more costly than allowing accountability to proceed. Whether enough of the business and financial community that has been aligned with Trump concludes that the economic disruption of the tariff ruling's aftermath and the receiver-threatened business empire is costing them more than any policy benefit is worth. Whether the specific convergence of legal defeat, institutional constraint, and practical governance failure reaches the threshold that Nixon's defenders reached in August 1974, not because the legal situation requires it, but because the political mathematics of continued defense no longer adds up. Those are the questions the nightmare ruling is forcing, and the answers are being determined right now. The nightmarish ruling landscape is real, documented, and building through a specific convergence of legal tracks that is more threatening to the sustainability of the Trump presidency than any single dramatic ruling could be, because its power comes from the accumulation of multiple independent institutional findings rather than from any single contestable accusation. Here is what you need to understand about why the nightmare architecture is specifically and structurally more threatening to the sustainability of the Trump presidency than any single dramatic ruling could be. A single dramatic ruling can be characterized as overreach, as partisan activism from a specific judge, as one court going too far in a specific case that can be distinguished from others. The immunity framework applications, the tariff ruling, and the civil fraud enforcement are not a single ruling. They are an accumulation of independent findings from independent courts. The Supreme Court of the United States, the New York appellate courts, and the federal courts applying the immunity framework, each operating independently, each applying its own legal analysis to its own specific facts, and each reaching conclusions that individually and collectively narrow the constitutional protection and practical governance capacity available to this president. When multiple independent courts, applying multiple independent legal frameworks to multiple independent factual records, reach multiple independent conclusions that each limit the president's authority or formally document his unlawful conduct, the political defense that any single finding is partisan, or that any specific court overreach becomes progressively more difficult to sustain in the face of the accumulation. The nightmare is the independence and the accumulation together. Not one court being characterized as going too far, but multiple courts independently applying their own legal standards to their own specific facts and arriving at the same place. Now, let us be precise and historically grounded about what inevitable means in the context of presidential resignation and why that word is beginning to appear in serious analytical context in the writing of legal scholars and political scientists, who study how presidencies end rather than just in political content creation. Inevitable in this context does not mean legally required. No law requires a president to resign. Inevitable means politically approaching the threshold at which the specific political conditions that historically have been sufficient to produce a resignation. Bipartisan coalition fracturing. Economic disruption reaching the people who have been politically insulating the president. Practical governance capacity being so impaired by legal and institutional constraints that the presidency is no longer able to function as a presidency, are sufficiently advanced that the outcome is approaching the category of likely rather than merely possible. Nixon's resignation was not legally inevitable. It was politically inevitable, a product of specific calculations by specific political actors who concluded that the math no longer worked. And the question the nightmare ruling architecture is forcing is whether those specific calculations are approaching the point where the math changes for enough of the political actors whose choices actually determine what happens. Watch for any Republican senator who begins publicly engaging with the specific substance and legal reasoning of the immunity fight findings, rather than simply dismissing them as partisan. Because substantive engagement, which requires acknowledging the legal framework and its application to the specific facts, is the first stage of the political calculation that eventually produces the math change that matters. A senator who dismisses a finding as partisan is still defending. A senator who says the framework is reasonable even if they disagree with this specific application has started calculating. Watch for any major financial institution or business leader aligned with Trump who publicly expresses concern about the governance and economic consequences of the tariff ruling aftermath, because that constituency is the economic analog of the Republican senator who told Nixon that the votes were not there. And watch for any internal White House signal about succession or transition planning, however indirect. Because that kind of signal in historical precedent has consistently indicated that the internal calculation about sustainability has changed even when the public posture has not. Here is the complete and honest picture. Trump has never resigned from anything. His entire public identity is built on the persona of the man who does not quit, who fights back harder when attacked, who treats defeat as a provocation rather than a conclusion. The bar for a resignation from someone with that specific psychological and political profile is extraordinarily high, higher than the bar that applied to Nixon, who did not have the same relationship with the base or the same sense of the presidency as a personal mission rather than a governmental role. The legal exposure is real and documented in published judicial opinions. The court rulings are on the record and have survived every appeal that has been attempted against them. The nightmare architecture is being built one decision at a time in public proceedings. But the path from a nightmarish ruling landscape to an actual resignation runs through a specific political calculus. The changing calculations of specific political actors that has not yet reached the threshold level that historically produces the outcome. What the nightmare ruling does accomplish, what it is already accomplishing right now, is advancing toward that threshold in ways that make the conversation about it rational rather than purely speculative. It is building the specific combination of institutional findings, political pressure, economic consequences, and governance impairment that historically precedes the threshold. It is not the threshold itself, it is the approach. And the question of whether and when the approach produces the outcome depends on the choices of specific people. Republican senators doing their own calculations about what the immunity fight opinions mean for their own political standing. Business leaders reassessing their alignment in light of the tariff ruling's economic consequences and the civil fraud enforcement's threat to the physical brand they have been associated with. Cabinet members privately considering what history will say about their service in an administration that the Supreme Court has officially documented as having broken federal law. They are each watching the nightmare unfold in the specific ways that affect their own interests and reputations, and each deciding privately and on their own timeline what they are going to do about it. The nightmare ruling makes those decisions more urgent and more costly to defer. It does not make them for the people who have to make them. That is the specific constitutional truth of the moment. The architecture is built. The pressure is documented. The convergence is measurable. And in the moment when enough of those individual decisions converge, when the specific political math changes in the specific ways that historically precede the specific outcome, the headline describes a moment when the inevitable becomes actual. That moment could arrive with very little warning from the current trajectory. The immunity framework continues to generate new opinions. The tariff ruling's economic consequences continue to unfold. The civil fraud enforcement continues to move toward receiver action. Each day brings new developments, new findings, new pressure points. And each day brings the specific political actors whose choices will ultimately determine the outcome closer to the moment when they have to decide what they are going to do. The question is not whether the legal architecture is formidable. It is. The question is not whether the political pressure is real. It is. The question is whether the cumulative weight of everything the courts have been building will eventually produce the specific political calculation that makes continued defense more costly than allowing accountability to proceed. That question does not have an answer yet, but the trajectory is clear and the historical precedents are instructive. When multiple independent courts apply multiple independent legal frameworks to multiple independent factual records and reach multiple independent conclusions that each limit presidential authority and document unlawful conduct, the political defense becomes progressively harder to sustain. And when the economic consequences of those rulings start affecting the people who have been providing political insulation, the calculus changes in ways that are difficult to reverse. This is why serious analysts are using the word inevitable in serious contexts. Not because they believe it is certain to happen tomorrow or next week or even this year, but because the specific convergence that historically produces resignation is visibly building in ways that are measurable and documentable. The immunity rulings are accumulating. The tariff ruling is producing real economic disruption. The civil fraud enforcement is moving toward tangible consequences, and the political coalition that has been defending Trump is showing signs of strain that were not visible a year ago. The nightmare architecture is real, it is growing, and it is forcing choices that the people who have been protecting Trump would prefer not to make. But those choices are coming. The only question is when and how they will be made. Stay locked in because this story is far from over, and the moment when the inevitable becomes actual could arrive faster than anyone expects.